Good afternoon, everyone. This is the monthly cadence of ANPA Financial Webinar Series that is put together by ANPA Foundation, one of the branches of ANPA. ANPA, by the way, is the Association of Nigerian Physicians in the Americas. I am sitting in for the president of ANPA, who usually hosts this meeting, Dr. Stanley Okoro, who has another business engagement as we speak. What we're going to do today is listen to estate planning basics. Like I said, I'm Philip Osehobo. My boss, the president, is not available.
Yeah, I've been here.
Yeah. Oh, okay. Dr. AK is here. So Dr. Cliff AK is our ANPA national president. He showed up. I thought he was chilling or playing soccer, so he's glad to have him. Dr. AK, our national ANPA president, will speak briefly to welcome us to this series while we are looking at a slide about who ANPA is. Dr. AK, please.
All right. Thank you, Dr. Sayobo, for filling in for Dr. Stanley Okoro, who is the president of ANPA Foundation. And I'm the president of ANPA. I want to thank all of you. It's one of the benefits to our members. And I also thank ANPA members for a wonderful ANPA week and the ANPA convention in Lagos. You hear more about it outside here, but I want to use this opportunity to thank everybody who participated and made it a resounding, one of the best in our 30-year history. Estate planning is very important. Thanks to Drs. Hezi and Renee Adesanya, who are sponsoring this webinar. And of course, our subject matter experts, Mo Datka, I hope I said it right, and then Adam Katz. We're willing to learn from you, and this is being recorded for our members who couldn't make it to also listen. For the sake of time, I'll stop there, and Dr. Sayobo, back to you. Thank you.
Thank you, Mr. President. Thank you very much for joining us. Appreciate it a lot. So, like our president alluded to, these are part of the benefits of being a member of ANPA. This kind of lessons or networking or referrals, professional development that we do. And this is how you connect with ANPA. We encourage everyone to please become a member of ANPA by going to these platforms. You have a lot to benefit from. And if you have any concerns, you can always contact membership at ampa.org. ANPA Foundation has three main purposes. It's the 501c3 charitable foundation arm of ANPA. Our goal is to raise funds to create some independence for ANPA fiat philanthropy, create sustainable systems of healthcare and beyond, and educate members on issues like we are discussing today, estate planning, legacy, and generational wealth. Today's webinar is 1 hour, and we hope you're going to make the best use of your time. And the materials here are presented for just general educational information purposes only. We are not experts. We still advise you to please go and get expert financial and legal advice. Neither speakers nor ANPA is responsible for any errors that are made in this presentation, and it shouldn't be construed as endorsement by ANPA either. All right, so take it from here, Mr. Datka and Mr. Katz. As we said, the sponsors of these are Drs. Hezi and Renee Adesanya, ANPA members. Dr. Adesanya, Dr. Renee or Dr. Hezi, you have a few introductory comments before you hand it over to the lead speaker, Mr. Adam?
Thanks, Philip. I'll let my wife do the introductory thing. She's more vested. She's more in deep in this than me. I just want to say one thing, that the official recording for ANPA is being done to the cloud. So anyone who needs a copy of this should request it. I've had to remove 2 participants who are putting on the AI and doing recording. Let's kindly follow the rules. Once the recording is done and made available on YouTube, actually, but you can always make your request. Thank you. Over to you, Dr. Ronnie.
Hi, thank you, everyone. Good afternoon. Thanks for the opportunity to present. I just think it's important for us all, especially as people in diaspora, to understand the estate planning so you make sure you are well informed and you can do what you need to do for yourself and your family. So I have brought part of our team. Mr. Adam Katz is the CEO of Adam Katz Agency, and he's going to take it away, tell us a little bit about the organization and some things. And also, Mo is our attorney. Like he said, he's the son of a doctor who refused to be a doctor, kind of. So we're glad to see you, Mo. And they will be presenting and asking. You're able to ask questions. The objective is for you to leave here well informed, that you don't want to leave money on the table, especially when we transition out of this world, which is a pay we all have to pay at one point or the other. Thank you very much. Over to you, Adam.
All righty. Thank you so much, Dr. Rani, and I appreciate everybody joining us this morning. So we do have a slideshow, but for the most part, we're going to just kind of talk without necessarily going through all the slides. Very fortunate to have Mo Datka with us today. He is our Chief Legal Counsel with Integrated Trust Systems, which is who we are partnered with to do the estate planning. And just a little bit about my background and how we got into this partnership. I was a school teacher. I spent 7 or 10 years teaching 7th grade social studies, and I quickly realized that the difference I was making with those kids were, for the 1 hour a day that I was able to meet with them, was being undone every time they went home to poor home situations. And so one of the reason I got out of education, I decided that if I could help the parents get their situations better, that would have a longer term and more impactful impact on the kids. And so that's where I got out of education and got into the financial world, working with financial planning and insurance and different products along those lines, helping people expand their retirement thought processes and things like that. As we did this for a number of years, we realized that a financial plan without a legal plan can lead to chaos. And that we were helping these people with a financial plan, but they had no legal plan behind it, which was going to impact the generational wealth they were trying to create and just the transfer of their assets long term. And that's what we started looking for, a partner that we could partner up with to help us with that legal plan. And that's when we found Integrated Trust Systems. Integrated Trust Systems, A+ rated company based out of Arizona. They've been in business since the mid 80s. They have over 23,000 estate plans set up that they are currently managing all across the country. And I have thousands of clients across the country as well. So we brought the team together. Chris Norris runs our wealth division. Mo Datka is our legal counsel. We have partnerships with trust companies. We have partnerships with tax accountants who can all help us under one umbrella handle the tax, the legal, and the financial processes that are important to people as they move on. I'm going to let Mo introduce himself more about his background, and he is going to do the brunt of the education today because of the time limits and everything else. We're kind of streamlining the seminar down into handling more of the legal aspects of why you want to have an estate plan in place and what happens if you don't have an estate plan in place. So Mo has been such a blessing to our organization in the time that he's been partnered up with Integrated Trust Systems and with us here at the Alliance. He's so available, so knowledgeable, and brings so much connectivity to the table that we've just enjoyed the partnership so much. And so with that, Mo, I'm going to turn it over to you and mute my line in case there's background noise where I am, and let Mo go into the estate plan.
Thank you, Adam, and hello, doctors. Dr. Phillip explained, I do come from a line of physicians, so I have a lot of respect for what all of you do. I was not good at math and science. I was actually pre-med bio before I became an attorney. Organic chemistry was my stopping point there. I was not very good at that or genetics, and I let my poor dad, who's a cardiologist, down and went to law school instead. But I did graduate in 2009, and I opened my firm right out of law school. 2009, if you were practicing, was a tough year. That 2008, 9, 10 job offers were hard. So I have owned my own practice since 2009. I've worked primarily in the areas of real estate, corporate law, and estate planning. And how that brought me to integrated trust systems was I take a holistic approach at everything. Many of you might be business owners owning your own medical practices. I'm sure all of you own some real estate and you have other assets, and all of that are items that go into your estate planning. And my entire career, those 16 years, I've just been practicing in those areas. I don't get out of that. I don't do any medical malpractice. Don't worry. I knew I couldn't do that if I had a dad that was a doctor. So everything I've done has been in those areas of law. When it comes to estate planning, people have a lot of misconceptions. Most people have grown to understand a will is something they should have. The problem is that a will alone is not enough. Most people go through life thinking I should have a will, and a will alone is a one-way ticket to probate. So there's really three options that the average person has when it comes to their estate plan. Option one is do nothing. And if you don't do anything and you, God forbid, pass away, and we all do, you're doctors, you know, eventually we all have an expiration. If you do nothing and you have no estate plan whatsoever, you pass away what the law calls dying intestate. So depending on what state you're in, your state's laws decide what happens to all of your assets. So typically, if you have a wife and kids, some percentage of that will go to your wife and kids. If you don't have those, it might go to parents or siblings, but your state decides where it goes, and you will end up in the probate courts. Not you, your loved ones will, to be able to figure out how that distribution occurs. You'll have to hire or your loved ones will have to hire an attorney. They'll have to pay some probate fees. They'll have to pay the court. And then all of those fees are going to come out of your assets. The second step is that you create a very simple estate plan. You have something called a will that I just spoke about. That will then decides where your items go. So you can say, well, I want 50% to go to my kids, 50% to my wife, or I want everything to go to my kids. And I've lined out what I want to happen with my stuff. But if you only have a will, you will end up, your loved ones will end up in probate. Your executor will still have to go to probate. Courts will have to take your assets from your names, and now you're gone, and spread it out amongst the people that you have expressed the interest in the will to have your assets. Most people want to avoid that altogether. They don't want to send their loved ones through probate. They don't want to create a system where once they're gone, their loved ones have to spend money, time, potentially create infighting amongst their family members. I think everybody who's on this chat has heard a bad story about a divorce attorney. Divorce attorneys get a bad rap because they're typically gaining their income and their money from a situation that's difficult. People are splitting up and divorce attorneys are charging money, and that's never looked at in a positive light. Well, when you pass away, if your family members are fighting, unfortunately, probate attorneys are very similar. Now, they might not have the same level of aggression as a divorce attorney, but they're charging hourly legal fees that are really coming out of your assets, coming out of your estate. So a proper estate plan avoids that altogether. What we create for 99 out of 100 of our clients is a properly funded revocable living trust. And that's the centerpiece of an estate plan. An estate plan is not just trust planning. So within an estate plan, you should have a proper trust, and working off of that, you should have things like powers of attorney that spring into being during incapacity. So God forbid somebody ends up in a hospital, or you end up in a hospital, and now you can't make medical decisions on your own behalf. You need to designate somebody to do that so that you don't wait until it's too late. Somebody ends up in the hospital, and then now your family has to run around and go get guardianships or coin-apported conservatorships. So estate plan will have a revocable living trust. It will have your powers of attorney. It will have medical directives. I'm sure those of you who've obviously been in the medical field long enough, you've had the scenario where somebody's come in and they have no medical directives lined up. So it's a bit of a guessing game for the family. Who's going to make decisions? What decisions will they make on behalf of the person who's now incapacitated and can't speak for themselves? So these are all things that are in a proper estate plan. Now, there's the option to do an irrevocable living trust, which is something that we do provide. That is what we call our Nevada Wealth Preservation Trust. But 99 out of 100 people, myself included, I have a revocable living trust. And with a revocable living trust, there's typically two main advantages. Advantage number one to any revocable living trust, whether you do it with us or you go to a law firm, is one, that probate avoidance. And a properly funded revocable living trust avoids probate altogether. And I'll talk about what I mean by funding in a second. You don't have to pour money into the trust, but we do have to assign assets to a trust. And that's in a traditional law firm where most people get themselves in trouble. But advantage number two is that a revocable living trust is amendable. It's changeable. By its definition, it's revocable. You can actually get rid of a revocable living trust altogether if you want. But for most people, life takes them in different directions. Very rarely do you create a trust today and die tomorrow. Sometimes we do have clients come to us who are very late stages. I spoke to a lady last week who unfortunately was about to go into hospice, very late stage cancer patient, and she didn't have an estate plan. And we created that estate plan, by the way, in 24 hours for her. The advisor came to us and said, we have a really tough scenario here. This poor lady doesn't have a lot of time. Can your staff be very quick? And within 24 hours, we gave her a properly funded trust. So she could go into hospice knowing that her family was not in a scenario where they would have to go to probate. But what we typically do at the Revocable Living Trust is set it up, and then our client is alive for very many more decades after that. Well, life takes you in different directions. You're going to buy new assets. You might sell some of your assets. Your families might grow. You might end up having grandchildren. I can tell you, we get a lot of people coming back to our platform the moment they've had grandchildren and say, now I need to take account for my grandchildren. Because I can tell you, I have kids of my own. The moment I had kids, my parents love my kids more than they love me. The Revocable Living Trust allows you the latitude throughout your life to make as many changes as you want, as often as you want. The other advantage is laws change. So every administration has a new set of laws. With a Revocable Living Trust and our platform specifically, we help you with jurisdictional changes. And I'll talk about our platform a little bit more in a second. But basically, if new laws come about and they're advantageous to you, we'll come to our platform. We'll let every client know, all 23,000, we've added some new language into our trust moving forward. Let's take advantage of these good new laws. And if the client wants, they don't have to, they can always keep their original language. But if they want, they'll select a couple buttons on our platform and the new laws are entered into their trust. Or if laws go in the wrong direction, because sometimes that happens, and we have bad laws, we as a platform will try to craft language to help mitigate those bad laws. And we'll do the same thing. We'll let you know we've added some new language to help you out. So having a document that works for your life's needs, but also for the law's needs and avoids probate makes the Revocable Living Trust very beneficial to the vast majority of people. So if you decide that of those three options that you want a proper estate plan, once you've made that decision, there's really only two ways to go about getting a proper estate plan. It's difficult to figure out how to do it on your own. It's too cumbersome. I would never pretend to know what I'm doing on the medical side. And I tell my clients, when it comes to legal documents, especially ones that have to do with the entirety of your asset base and your family's wealth, you don't want to try to do it yourself. So most people have two options. One, you go to a traditional law firm, which is what I did for the vast majority of my 16-year career. For 15 years, I was the attorney that did traditional estate planning. Somebody would come into my office, I would sit down with them, or my paralegal would. We would go through a lot of different scenarios. We would create an estate plan, and then we would hand that estate plan to the client, and we would tell them, now we've created your estate plan, but we need you to go fund your trust, because law firms don't. Why don't law firms fund a trust? Well, for the vast majority of law firms in states, you need to retitle the assets into your name. So law firms don't want to run around for you, go to your Chase Bank, your Bank of America, write, all the letters they need to write to all of your financial institutions, go to the Department of Motor Vehicles and do the retitling for two reasons. One, it's a lot of work and they can't charge for it. And two, it's liability for the law firm. So they don't want to do it. And if they were to charge their time, estate plans would be $20,000, $30,000. So the vast majority of clients that leave a law firm with an estate plan don't actually fund their trust. So what ends up happening when they pass away? Their family still ends up in probate. And when I first met the folks at Integrated Trust Systems, the creator, Gary Lofsgaard, I think you saw his name on the screen, I wanted to ask a lot of questions. I said, I have a pretty successful practice. What do you guys do different than I'm doing right now? And he asked me a very important question. He said, Mo, you seem like you're a smart guy. He said, do you have a trust for your family? I said, I do, Gary. He said to me, is your trust still properly funded? And I said, no, there's some assets I don't have in the trust right now. He said, so if you walked out of this meeting and you got in a car accident, will you end up with your family going through the probate system? And I said, yes. He said, and you're an attorney and you're a actual real estate planning attorney and your family will end up in probate? I said, yes. And from that moment on, when I realized that their system does the funding up front, I moved all my clients to their system. The problem with probate is it's long, it's costly, and it creates that sort of infighting. So the vast majority of law firms will not fund. Remember, I said the two main benefits are avoiding probate if it's funded, and then benefit number 2 is being able to make those changes. Well, the vast majority of law firms, if you want to make a change to your estate plan, what they're going to force you to do is come back to the law firm and say, well, I just had a grandkid, or I've just had a new set of assets, and I've had a change of wishes. I want to make sure that my son, he's 21 now. I thought I was going to give him the money, but he's a little bit irresponsible. I want him to get the money at 25 or 30. I need to make changes to my trust. Most law firms are going to charge you an hourly legal fee. So the vast majority of clients that go to a law firm for their proper estate plan over the course of their life spend a lot of money making those changes. With integrated trust systems, those two benefits, making sure your trust is properly funded and then being allowed to make changes as much as you want, are made easy, because our first step in the process is to fund your trust. And then changes that you make throughout your life are at no additional cost. Why? Because we have a digital platform. So the second option for most people is to create an e-estate plan. And what we do at Integrated Trust Systems is first meeting that you have is with one of our funding specialists. They take your assets and they help fund the trust. The second meeting is with an implementation team member, our paralegals. They go through who your loved ones are, where you want your assets to go. The third meeting is actually with our legal team, and we actually go through all the law with you. We make sure everything is done the right way. And by the time you leave us and the CATS team, you have a fully funded trust that you can amend and adjust at any time that you want. So we take care of your trust work. We take care of the powers of attorney. We take care of all of the medical directives. And then we hand you a trust in a platform that will allow you to keep that trust funded and working for you throughout the duration of your life. And the nicest part, I think, of the platform is anytime you need help, you can always come back to the platform and ask questions. So I actually encourage it. You will likely go through life becoming an expert in your field, and you will not stay on top of what you have to do when it comes to estate planning. So we have something called our Notepad Center. Anytime one of the clients has a question, should I change a language? Should I fund my trust with something else? Should I do something different? By the way, I need help. We as Integrated Trust Systems staff, within 24 to 48 hours, make all those changes for you. And then again, hand you back off a trust that works for you. So what I always tell my friends, my family is, if you have no estate plan, you need one. Because if you have, and this varies from state to state, but some states have a $20,000 barrier. Some states have a $50,000, some 100. I think the maximum barrier is about $150,000 or $180,000 of net worth. If you pass away without a properly funded trust and you don't have the right designations on your accounts, your family goes through probate. So you need a trust. The steps moving forward is, what do you do? Do you go to a traditional law firm, or do you do this more, I would say, technology-based set of estate planning that will continue to work for you for the duration of your life? The reason we're able to fund so easy is because we use law based on the state of Nevada for your trust. Your last will and testament, something that we include called a pour-over will that should be attached to a revocable living trust, will actually be keyed to your specific state. So anywhere you live in the country, our estate planning will be coded to your state when it comes to your will, but your trust is created under the situs of Nevada law. Why can we do that? Why? I live in Illinois. Why do I have a Nevada-based trust? Well, Nevada has the best set of laws for estate planning across the country. Integrated Trust Systems is actually an Arizona-based company. They simply use Nevada law for the situs of their law, because it's better law for you, the clients. The full faith and credit clause of the US Constitution allows you to do that. Similar to companies that set up Delaware LLCs and then migrate their LLCs to different states. You can have a Delaware LLC and operate in all the rest of the states. You can do that with your properly funded revocable living trust. Why? Well, the law knows that we move around. If I don't like my cold weather in Chicago and I want to decide to move to Florida or North Carolina or Nevada, it would be unreasonable every single time that I move to have to create a new estate plan. So the law allows you to take advantage of the situs of any state's law. So we picked Nevada because we think it's the best law. But the rest of our estate plan will cater to your individual state. We have clients in all 50 states, Alaska and Hawaii included, and our revocable living trusts are made to cater to the state laws across the country. So that's a little bit about us. I rushed through it knowing that we only have a little bit of time to talk here, but I'm open to answering any questions you guys might have as well.
Thank you, Mr. Moore. Mr. Katz, I guess you still have a few items to add before we open it up for questions. Just want to mention that just for the audience, we didn't really have to follow the slides as you can see, but he went on and I tried to follow, but I think we got the gist. But I allow Mr. Katz.
Yeah, the slides were for a much longer presentation.
Yeah, so I just wanted to know that. Yeah, but that's good.
I apologize for that. That was my fault. We kind of made audible at the last minute on the best way to present this information to you guys in the most succinct possible way. And going through the slides would have been more of a distraction. So yeah, this is. Sorry about that. That is on me. So yeah, do you want to open it up for questions?
We could. I thought if that was your plan, then we could open it up unless you had one or two items to add. But I know you mentioned at the beginning that Mr. Moore will do a lot of the heavy lifting. So yeah, we can open up for questions. Please, if you have questions, just indicate by using the raise hand thing, and then I can recognize you. Yeah, Dr. Adesanya, your hand is raised. Go ahead.
Yes, please, can you explain, thank you very much, Mo, for the presentation. Can you explain the difference between revocable and non-revocable trusts?
Yes, ma'am. So there's revocable, there's irrevocable living trusts. An irrevocable living trust is by its definition irrevocable. So you're going to take your assets and you're actually going to transfer them out of your name into an irrevocable trust for the benefit of your beneficiaries. And then if you want the latitude and flexibility to sell those assets or control those assets, you've given that control up. Why do we use irrevocable living trusts at all? Typically, it's used for the ultra wealthy. And that might be some of you doctors. And if that's something that you want to use, we would consider doing that with you because we have a Nevada Wealth Preservation Trust. But most people, depending on where your asset base is held, even if you have tens of millions of dollars worth of net worth, can get away using the revocable living trust. If I see somebody has 20, 30, $40 million worth of net worth, we'll start to use elements of an irrevocable trust. And the beauty is you can actually have both. You can have an irrevocable living trust for part of your assets, revocable for the other. But it handcuffs you in a sense where it truly becomes, in a sense, irrevocable. What the law doesn't want you to do is have the benefits of the irrevocable living trust when it comes to asset protection and some of those generation skipping taxes and things we can do. But leave it revocable. So if they think that you're going to make this irrevocable living trust, and then you want to say, well, you know what, I changed my mind. I want to sell these assets. I want control of these assets. You then have to either ask all your beneficiaries to accept. And if they say no, you can't unwind that, or you have to go through the court process. So when I say 99 out of 100 people that come through our office fall into the category of revocable living trust, it's because even the wealthiest of our clients, Their assets may be set in a place like real estate where it might be in a separate LLC. It might be assets that we can make sure that we control in different ways throughout your lifetime, where we're not worried about potentially needing to use the irrevocable living trust to offset inheritance taxes, offset liability type scenarios. So it's there, we use it, but we use it very seldomly for the right client. Myself, I have some real estate. I have a couple different businesses. I didn't mention it, but I own a separate business that's a real estate brokerage with 50 agents here in the Chicagoland area. I obviously have my own law firm. I still have a revocable living trust. It allows me all the protections I still need for my family, but it doesn't handcuff me because I want to have an active control over my assets during my lifetime. Does that help?
Thank you very much.
Dr. Osemeke.
Thank you very much for that explanation, Mr. Mo. Excellent presentation. The question I have is actually twofold. The first is, when you make your trust revocable, in regards asset protection for most doctors that the malpractice lawyers are always around, can they get to your assets since it's revocable? Whereas in the irrevocable trust, where you give control to your family, or so to say, how do you talk about asset protection within this revocable and irrevocable trust, considering the atmosphere in which we practice? That's number one.
Yes.
Number two, it's just a question about, if you already have a trust, revocable or irrevocable, does your practice do like a second opinion kind of thing, where we can say, okay, this is what I got it about 50 years ago. What do you want to do with it?
Both very, very good questions. So to answer your first question, a revocable living trust on its own does not have asset protection. But I have this discussion with my dad, actually. Here's the reality, unfortunately, for the vast majority of successful people when it comes to asset protection. And I'm going to tell you kind of how litigation works and judgments work. When it comes to a judgment, let's assume somebody got a judgment against you, doctor. Even if your certain assets are protected, and we can do that, move some of them to an irrevocable living trust, the fact that you're continuing to work as a professional allows that judgment holder to garnish your wages. So if a judgment oversteps what your insurance will pay and you're an actively working person, they can still come after your wages. So even the irrevocable living trust, yes, we can carve some assets out to protect them, but depends on your asset base. Like I said, if you have real estate, what we do is we say, if you have real estate, we're going to take the real estate out of your personal name. We're going to move it to an LLC, a limited liability company, where that LLC holds your real estate. So now if you get a judgment against you personally, they can't attach to that LLC. And if you get a judgment against that property because a tenant slipped, fell, hit their head, that property itself, that LLC, is the only thing affected. Your personal assets are not. But yes, with a revocable living trust, if somebody gets a judgment against you, they can still come after your personal assets because you have that control. With an irrevocable, they can't. But even with a irrevocable living trust, if they get that judgment against you and you're a practicing physician and you're continuing to be successful, they can still come after you. And here's why. When somebody gets a judgment against you, a judgment's really just a sheet of paper. And I used to be a litigation attorney, so we used to get judgments on people. And then most of the time when you get a judgment against the average person, they say, I'm not going to pay you. They're going to say, well, thank you for that sheet of paper. Good luck. You can now come try to collect from me. So the next step after somebody gets a judgment is something called a citation to discover assets. And that's when the court actually lets the person who has the judgment go and try to find what your assets are. And part of that is, what is your job? How much money do you make? What do you have that even not now, but moving forward, if you acquire anything else, I can grab? So if you're the type of person that now is retired and you have all these assets, well, your liability is lower, so you might not have that problem. But if you're an active practicing person that moving forward will create income and moving forward is going to, create more assets for yourself, well, you don't really avoid that liability in the malpractice space. And that's what I try to tell, especially when I sit with doctors. We want to sit and look at what your asset base looks like, because there's some doctors, you're just putting it in your checking savings, maybe your retirement account. There's some doctors I come to that have a little bit there, but they have a little bit in real estate, and unfortunately own all the real estate in their own personal name. And I say, well, step one is let's carve that out, because the best way to protect that asset is let's just move it to a separate entity all in of itself. We don't have to move it to a trust to protect it necessarily, or irrevocable trust. Let's just move it to a company. Let's move it to an LLC, because now your personal judgment doesn't affect the LLC. And if you get a judgment here in the LLC, it still won't protect it still won't affect your personal liability. So that's a great question. And it's a question that we take again, a holistic approach at, because we want to look at what's your asset base. If we think that it's something where this asset base leads us to need an irrevocable trust, we absolutely will take you there. And to your second question, if somebody already has a trust, my first question, even before I review their documentation, is this: did you keep it properly funded? Actually, the question Gary asked me personally, have you stayed within your funding parameters? Because if you haven't, then what we can do is let's just start from scratch, restate your trust if you have some assets in it. We call it a restatement of trust. We'll take the language you like from your prior trust and we can incorporate it if you want, but let's start from scratch. When I read a trust, half of them are actually pretty good. Half of them are very bad. Half of them, some attorney who shouldn't have been doing the work created it, and I'll just tell you they're bad. But half of them are actually, in their verbiage, very well-written trusts. The element that leads me to tell the client, let's start from scratch, is because they haven't funded their trust, because the method in which they set their trust up is forcing them to consistently stay on top of funding. And if you don't have a properly funded trust, all you have is worthless sheets of paper. Yes, you have a little bit of direction of where you want your properties to go, but your family still ends up in probate. So what you tried all along to avoid, you end up in this scenario. So anytime somebody has a prior trust, question number one, is it properly funded? Then we'll look at the language. If the language is good and it's properly funded, I tell you, you don't need another one. I actually had one a couple days ago, called me and said, Mo, I have this prior trust. I heard what you guys are doing. And I asked him the question, is it properly funded? He goes, yeah, I retitled everything. He goes, I'm crazy. I'm very detailed. Everything's retitled. I said, congratulations. You're 1 out of 10 people that do that. And I said, send me the documentation. I looked at it. I said, this is a really good trust. You really don't need us. As long as you keep it funded moving forward, keep it. So we're very honest. If we don't think that you need us, we definitely won't sell you anything. We don't need that, that sort of business practices. Like he said, I've been with the platform for a little while now, but they've been in business so long. They don't have a single Better Business Bureau complaint in 23,000 trusts. So Gary, the owner, he's 80 years old and he works every night till about 1 or 2 a.m. perfecting his system. He still emails me at 1 a.m. every night. But he's very detailed about customer service. So if we don't think you need a trust, we'll just tell you your trust is good. Keep it up to date.
Dr. Fawide.
Thanks very much. My question to Mr. Mo. I have a child with a disability. How can you plan the revocable living trust to include disability?
Wonderful.
That's one. Number two, I have some assets outside this country. Do those things need to be included? How do you include assets that are not in this country? And then you give me information how we can reach you.
Yes, sure. Two very good questions. First question about people with disabilities. So we have something called our Universal Guardian Trust. It's our version of a special needs trust, but because the term special needs has started to get a negative connotation, we actually name it a Universal Guardian Trust. And we have it for 2 different scenarios. People who are on Social Security disability benefits, we have one set of language. And then we also have language for people who just need it because we're concerned that they might not make the right decision for their financial circumstances. And it's a irrevocable sub-trust attached to your revocable living trust. We call it a third-party funded special needs trust. How does that work? So let's say you're a grantor, you're the person setting up a trust, and somebody in the family has special needs. What you end up doing is when you pass away, those funds never get dispersed to the person who's on the government-based care or benefits, who's special needs. They get dispersed directly into the Universal Guardian Trust account. And then the person who's the grantor, they designate somebody to be a trustee of those funds for the benefit of the person disabled. Because ultimately, the sad reality is in this country, if you have any bit of government-based benefits when it comes to disability, they allow you a very minimal threshold for assets. It's actually unreasonably low. They should raise it. It's not a fair number. But what we do is we never disperse those assets directly into the hands of the person on government-based benefits. We transfer it into an account with the trustee that has a lot of latitude to spend on their behalf. So it gets funded after the grantor passes away. One of the nice parts about what we provide in that trust is, first of all, it's 1/5 the cost of what you could get somewhere else. Second, the really nice thing is the platform allows for something called the Universal Guardian Guide. I had a call last week with somebody whose family member was very low functioning autistic. So almost nonverbal, very basic verbal cues. And she said the nicest part of what we did for her was we have it's like a 20-page guide where the family can leave notes about the medicine, the care, the people that the person should go see, their strengths if they like music, who they should be surrounding themselves with, dietary needs. They basically leave an entire file for the person that's taking care of their person with disability. That's if you have government-based disability benefits that meet a very low threshold. Now, if you're disabled and you don't have any sort of government-related requirements, then you can manage all of your own assets. My father, unfortunately, actually, although he's still a practicing physician, you guys might appreciate this, he spent 3 months in the hospital. He came out of the hospital now. He's got a ventilator, a trach, and he's in a wheelchair. He bought himself a handicap van. We have a caregiver for him. He goes to work every day and sees his patients. He can't do obviously any of his operations anymore, but he sees his patients even on a trach and a ventilator. He's a crazy guy. He's disabled, but he's able to manage all of his assets because he's not asking for government-based care. Now, I have proper powers of attorney in place for him in case something happens to him and now he can't do things on his own. I'm able to step in as that power of attorney to help him meet his needs if for some reason his disability takes a turn for the worse. And when it comes to properties outside of the country, so here's the reality of the honest truth about properties outside of the country. If you pass away and your property is still owned by you outside of the country, you need to make sure you do anything in that country to set up your proper transfer of assets to your beneficiaries. There's 2 countries right now that are very friendly with the United States when it comes to our trust, the United Kingdom and Canada. Now, Canada in 6 months might not be very friendly with us. So who knows what's going to happen given the dynamic right now between Canada and the United States. But every other country, you should set up your proper estate plan there. Now, if in your lifetime you sell that asset in another country and you migrate the proceeds of that sale to the United States, we then can set it up in an account that's assigned and funded into your trust so that your trust controls that. We have a page on our platform called the Postscript page. We also have a page called the eVault. The Postscript page is an instructional page. So it's really nice because it's instructions you can leave for your loved ones when you're gone. You can say, I have property in this country. The deeds are all attached and all the transfer documents are attached in the eVault where we house all the documents for your loved ones. So when you pass away, your loved ones don't have to go scrambling and trying to find the documents. We actually have the documents all in one clean place for your loved ones. So my family actually owns property out of the country as well. My dad has property in the Middle East. Some of the property is still there. Some we've sold and we've brought the proceeds here and attached them to the estate plan because we put them in US-based accounts that are assigned to the trust. But the assets that are in that foreign country, we actually have to set up the proper legal framework in that country. Because the reality is every other country, if you bring them a US-based trust, they're going to look at it and say, well, this is nice, but you still have to go through our process. You still have to pay our country's taxes. So we give advice on how to leave documentation in place for your loved ones to know how to address that country's laws, but your US-based trust cannot, control your property in other states. You will still have to go through that country's laws. And how to get a hold of me, I am on Integrated Trust Systems. So I'm a resource through the CATS team. So if you ever want to reach out to me and you reach out through the CATS team, I am with Integrated Trust Systems. I have my own independent law firm. So if you guys want to look me up, you can. But when it comes to estate planning, because of my role with Integrated Trust Systems, I actually do my estate plans all now through Integrated Trust Systems. So you'd have to be a client of the platform. But if you ever want to reach out to me, my information's all online. If you do Google me, you'll probably see a lot of race car driver stuff. I do race cars professionally as a side gig. So don't be alarmed. I still work 80 hours a week as an attorney. I just sometimes go and drive race cars, but your US based trust won't have that much control unless it's UK based or Canadian based over those foreign properties.
And
so there's a question in the chat that talks about if you could throw some light into what a properly funded trust means. So
yes,
before he does that, please, let me just say that I did post the information. You can text the number there, 609-213-2122, and text ANPA 2025.
okay.
That's the way you'll be able to reach the team.
Yeah, Mr. Kaz also posted something too. So yeah, guys, look at the chat. You'll see some information on how to reach the team.
Yeah.
And if I could say this, if you reach out to me through my cell number or my email, if you would also include the tagline of ANPA 2025, so that I know exactly where the request is coming from. I would appreciate that.
Good.
We made a commitment to donate. Part of our effort where we get transactions done through this platform presentation today, we have made a commitment to have donation to ANPA. So it's important for us to know you are coming to us through ANPA 2025.
Very good.
Hey guys, I looked as we started, I looked at your mission on your website. I will, whether you guys use us or not, I love what you guys are doing. Like I said, medicine's near and dear to me. My dad, actually, personal story, when he immigrated here, he went to college in Florida, but he went to medical school in Guadalajara, Mexico, and he ended up learning Spanish to get through medical school and then came back to the United States. So he used to go back to Mexico all the time when he was a successful physician. He was the president of the Chest Pain Society of the US many decades ago. He used to go back and give his time back. I remember as I was a little kid, he used to go do that all the time. He used to lecture in Spanish down there. So I will, whether you guys work with us or not, I will leave a donation there later today on behalf of my dad. It'll come in with my last name, but I appreciate what you guys are doing with your foundation.
Thank you, Mo. We really appreciate that. I'm sure my president is very excited with that off-the-cuff donation. I'm going to spill the beans here too. We are coming to Chicago next year, so we're going to keep you informed of what we're coming to Chicago for. I know Dr. AK will get your contact to see how we can continue to collaborate. Thank you.
Come in the summer. Don't come in the winter.
Thank you.
We're definitely coming in the summer. I promise you that. Yeah.
June next.
Come here in the winter.
Yes.
Yeah, it'll be June next year. We'll be there.
Okay, wonderful. It's a wonderful city in the summer. In the winter, it is a tough city to get around, but a beautiful city with great food, great entertainment in the summer.
Right.
But
so the properly funded trust question, and then Dr. Chukwu has the final question. Let's do that.
Yeah, so, thank you, Dr. Abraham Chukwu. I just want to, you haven't spoken to us about the fees or rates for these trusts. I think it's something that we need to know.
Sure.
What are the cost estimates?
Yeah, I'll let Adam talk about the fees, but I'll answer the funded trust portion for you guys. So great question on what it means to be funded. So when you set up a trust, any trust, it's just a sheet of paperwork. You need to assign or retitle assets to the trust. So some states require a retitlement. We use a state set of laws that allows you to assign your assets to the trust. So what the law wants to see is in our case, we create a ledger that's signed and attested to of your assets that are being assigned to the trust. The law wants to see that you, the grantor, the person who created the trust, intended on the asset that you have assigned to the trust to be held by the trust to be passed along to your beneficiaries without going through probate. Why the law forces you to do that is because there are sometimes assets and financial documents and things that you don't actually run through your trust. I'll give you an example. One of my businesses, my business partner and I, who are not in each other's trusts, we have life insurance on each other. We call it key man insurance. If one of us passes away, the other gets paid. He's a beneficiary on my life insurance policy and vice versa, but I'm not running that through the trust itself. So the law knows that some assets are not meant to flow through a trust. So it then, because it knows that, forces you to take all the assets that you want dispersed through the trust to get assigned to the trust. So we actually, our first step is you meet with somebody from our team and they go through all of your assets with you. What are your bank accounts? What are your checking accounts? What are your retirement accounts? What homes do you have? What motor vehicles do you have? And which one of these are you going to assign through a trust? And for the vast majority of people, most of their assets will go through a trust. Now, again, if you own multiple real estate properties, our recommendation will then be, let's get them into an LLC, and then let's assign your LLC's membership interest through the trust. So, what your ownership is, if you want, let's assign those through the trust. But a trust has to have assets assigned to it. You don't have to pour money into a trust every year. You don't have to pay a trust, but you must assign your assets to the trust that you want to avoid probate and that you want to flow through the beneficiaries that are in your trust. So that's what funding is. And the problem with funding for most people is you acquire more assets throughout your life. So the day that you set up your trust is usually, again, not the day you die. You guys are very successful as a bunch. So you're going to have more homes. You're going to have new accounts. You're going to open new banking accounts. You'll buy new motor vehicles. And the traditional way of funding a trust is to have to go and do all of that on your own, retitle every asset. Because we use technology, it takes us, this is not an exaggeration, about 60 seconds to assign each new asset to the trust. So we make it, and throughout the process, we give you an education on this. We show you where to go to assign the assets to the trust so that as your life goes in different directions, if you acquire assets, it makes it easy for you to keep a funded trust. I'll give you an example. My wife wanted a new car. Her car comes in next week. The moment that car gets bought, I'm going to remove her old car from my asset inventory list. I will assign the new car to it and I will fund it to the trust. And we give you that education through the process itself. I will let Mr. Katz talk about the cost because I am indirect with integrated trust systems. I don't do any of the cost work there. The individual agents actually do.
Thank you, Mo. Thank you, Mr. Katz. I don't know if you have any comment as we round up, Mr. Katz. I would like Dr. Adesonya, Rone, and Dr. Cliff Eke, our president, make some passing remarks, less than 30 seconds each. But Mr. Katz, you have the floor.
Yes. So to answer the question, obviously it depends how complex your trust is. If you're going to need additional assets besides just the revocable living trust, but the revocable living trust itself, which includes your power of attorneys, your healthcare directives, your healthcare power of attorney, the portal access to Mo and his team, and all of those things, is $2,995 all in. If you need the Universal Guardian Trust, that would be an additional charge. If you go into the wealth preservation side of needing those kind of things in the trust, those could also generate additional charges. But for 90% of our clients, we are all in at $2,995. And then there is an additional $95 a year maintenance fee, which allows you to continue to have access to make those changes, to keep it active, to keep to access the digital platform, along with the attorney oversight on every change that you make. So $2,995, which, to be honest with you, to get an all-in trust with everything included. By the way, that's a national price. It's not based on where you live. and that gives you all access to Mo and his team and his expertise on this digital platform, making sure that that is taken care of for you. So yeah, that's the cost on that. And I will turn it over to Dr. Ronnie.
All right, thank you very much, Mo and Adam, for this very insightful presentation. And thank you, ANPA, for the opportunity to share. Like we said, whether you're sending a text or you're calling, ANPA 25 is what you need to tag in. I think it's 25, or is it 2025? One of the two. But we look forward to facilitating you, ANPA 2025. We look forward to facilitating you because there was no time, but if you were looking at the slides as the doctor was sharing it, displaying, then you see a lot of prominent people that you all know about that had to go through probate that was very, very painful. So we want to make sure that we all avoid that. Thank you very much for the opportunity.
Thank you. Our president, Dr. Ike.
Yeah, Professor Seyobo, you look very sharp, by the way, before I forget.
Dr. Okoro said I should look good when I'm doing this job, so I have to make sure I don't.
Yeah, thank you so much for anchoring this. Again, a spectacular presentation webinar. Thanks to Adam and especially Mo, our subject matter experts, and of course, Doctors Adesanya, our sponsors. ANPA is doing a lot of good. You go on our website, we're just giving back, not just to Nigeria, but our communities here in in the US where we serve. Our next meeting for ANPA in general is our winter meeting, first weekend in November. We're going to share that later. And the big one coming in Chicago, June 3 to 6, 2026, will be at the Hilton Oak Brook. And we're looking forward to meeting more at that, and hopefully Adam at that event. You guys can come and have a booth and showcase what you have. This has been very, very informative. Even I have an estate, but I got to go and look at it again and maybe reaching out to you to see how you can help us with estate planning and especially taxes. Taxes are my headache. So you guys you can help us with that. Thank you so much.
All right.
Thank you, doctors. By the way, taxes are my headache too. They're everybody's headache. And I do like the bow tie and the suit. It's a very nice touch.
Thank you very much, Mo. Thank you, Mr. Katz. And thanks, guys, for joining today. Stay tuned for more of this webinar series from ANPA Foundation. Bye.
Thank you, guys.